Someone owes you money and won't pay. You're not about to hire a lawyer over $800. So what do you actually do? That's exactly what small claims court exists for. It's built specifically so regular people can sue for money without a lawyer, without complicated procedure, and without spending more than the amount they're owed. By the end of this video, you'll know exactly how to file, what to bring, and how to actually get paid if you win. Because winning and getting paid are two very different things. Small claims court exists in every state, and it's designed to be fast, cheap, and simple enough to handle without a lawyer. Cases usually get resolved in weeks, not months, and filing fees are typically under $100. It's meant for disputes over a specific amount of money, unpaid rent deposits, unpaid work, damaged property, broken contracts, that kind of thing. Step 1. Check whether your case actually qualifies. Every state sets a maximum dollar amount you're allowed to sue for in small claims. In California, the limit is $12,500 for individuals. In Texas, it's $20,000. In New York, it's generally $10,000, and in Florida, it's $8,000. These numbers change over time, so confirm your state's current limit before filing. Suing for more than the limit usually means waiving the extra amount or filing in a different court entirely. Also note, small claims court goes by different names depending on where you live. Justice court, magistrate court, and county civil court often refer to the same thing. Step 2. Make sure you're suing the right person or business. If you're suing a business, you may need its exact legal name, not just the name on the sign outside. A quick search of your state's business registry usually clears this up. Suing the wrong legal entity is one of the most common reasons small claims cases get thrown out before they even start. Step 3. Send a formal demand letter before you file anything. Several states actually require proof that you tried to resolve this directly before the court will hear your case. A demand letter is simple. State what you're owed, why, and give a clear deadline to pay before you take legal action. Keep a copy. If they never respond, that letter becomes evidence that you tried to resolve this reasonably. Step 4. File your claim. You'll typically file at the courthouse, in the county where the defendant lives, or where the dispute happened. This is called venue, and filing in the wrong location can get your case dismissed. Filing usually costs somewhere between $20 and $100, depending on your state and the amount you're suing for. Some states let you file online now, which can save you a trip to the courthouse entirely. You'll fill out a claim form stating who owes you money, how much, and why. Keep this part factual and specific. Step 5. The defendant has to be formally notified, which is called service. You generally can't just tell them yourself. Service usually has to go through the sheriff, a process server, or certified mail, depending on your state's rules. This step matters more than people think. If service isn't done properly, any judgment you win can later be thrown out. If the defendant is served and simply doesn't show up, you can usually win by default, just by showing up yourself and presenting basic proof of your claim. But don't count on that. Prepare your case as if they're going to show up and fight it, because sometimes they do. Step 6. Build your evidence before the hearing, not the night before. Contracts, invoices, receipts, and any written agreement are your strongest evidence. Save every text and email related to the dispute, especially anything where the other party acknowledges what they owe. Photos are powerful for property damage or unfinished work. Take them from multiple angles with visible dates if possible. If someone witnessed the agreement or the damage, ask if they can testify or provide a written statement. If you're thinking about recording a conversation with the other party as evidence, check your state's consent laws first. Some states require both people to agree to being recorded. Organize everything into a simple folder in chronological order. Judges move through a lot of cases in one day, and a clear timeline saves everyone time, including you. Step 7. Show up to your hearing, on time, with everything organized. Most small claims courts don't allow lawyers at all, or restrict them. This is genuinely a level playing field. You'll each get a chance to explain your side, present evidence, and answer the judge's questions. Stick to specific facts and dollar amounts. Judges respond to clarity, not emotion. Bring copies of everything. For yourself, for the judge, and for the other party. The most common mistake people make is showing up with a story instead of documents. The second most common mistake is missing the statute of limitations. Every state has a deadline for how long after the dispute you're allowed to sue, so don't wait too long to file. The third is suing for more than the small claims limit, or suing the wrong party entirely. Now here's the part almost nobody talks about. Winning your case does not automatically get you your money. A judgment is just the court agreeing you're owed the money. Collecting it is a separate process you may have to handle yourself. If the other party doesn't pay voluntarily, you can request a wage garnishment, a lien on their property, or a bank account levy, depending on your state's collection tools. Some states also offer a debtor's exam, where the person who owes you money is legally required to answer questions about their finances under oath. This part can take time and additional paperwork, so factor that in before deciding a case is worth it for a very small amount. Let's cover a few quick follow-up questions. Can I sue a business instead of a person? Yes. Just make sure you have the business's correct legal name. What if I lose? In most states, you can't easily appeal a small claims decision if you were the one who filed. But rules vary, So check your state. What if the other party countersues me? It happens. Just make sure your own paperwork and evidence are solid regardless of who filed first. Do I need a lawyer? Almost never for small claims. That's the entire point of this court existing. So here's the takeaway. Small claims court is built for exactly this situation. Regular people, real disputes, without the legal fees. Check your state's limit, send a demand letter, file correctly, serve properly, build your evidence, and show up prepared. This video is general education, not legal advice. Rules, fees, and dollar limits vary by state, so confirm details with your local courthouse or a licensed attorney. If this helped, check out how to fight an eviction notice step by step. Link right here. See you in the next one.